button.
Thank you.
Okay, state.
May I proceed, Your Honor?
Yes, you may. Thank you.
Good morning. My name is Italy Simmons, and I'm representing the prosecution along with my co-counsel, Carolyn Rinaldi. We will call two witnesses today, Justice Okafor, portrayed by Grace Fricker, and River Foley, portrayed by River Foley. May it please the court.
Yes.
On August 31st, 2019, the defendant, Haumea Robbins, shot and killed Haumea Robbins. Micah Opase shot and killed Haumea Robbins. This case is about a defendant whose romantic feelings turned violent. Opase was involved in a love triangle with Haumea and a third-party individual, Scott Farrar. Opase and Haumea had been friends for many years until Opase gained romantic feelings that weren't mutual. The friendship gradually ended with Haumea expressing that she didn't want to jeopardize their long-term friendship. However, soon after, Haumea began a romantic relationship with the third-party individual. This left Opase feeling betrayed and heartbroken, which then resulted in his making a threatening post on social media. He expressed his frustration and greed to make sure Haumea felt how she made him feel. After some time had passed, the defendant called Haumea with intentions to fix the friendship. However, he ultimately left her in downtown Harmony shot dead. The steamy emotions resulted in a murder of a genuine and caring young lady and left a single parent without their child. The prosecution will call two witnesses to the stand. We will call Justice Okafor, an assistant county prosecutor for Cardinal County, who also graduated from Buckeye State DeHaan School of Law in 2010. They will testify that the defendant was not denied their due process, as well as no substantial evidence was withheld. The outcome would have not changed. It's usual for the opposing counsel to contact witnesses on both sides, but for some reason it didn't happen. The defense was given a list of the witnesses and they had weeks to contact them. Lastly, we will call River Foley, a detective with the Harmony Police Department and has been a police officer for the past 24 years. They will testify that the collection of substantial evidence leads back to the defendant. The fingerprint found on the victim's glasses, the shoe print in the grease, and the fiber from the jacket all lead back to Micah Opase, as well as how steamy emotions present a strong motive. Defense may argue that the defendant was denied their due process. However, we will show that he would have received the same outcome with or without the witness ID due to the amount of substantial evidence and a strong motive. There's this old saying, when one door closes, another opens. This is exactly what happened to Micah Opase when he pleaded guilty and was notified that the witness was having a reservation. He saw a way to escape his consequences. He saw an open door. Don't let Opase escape the doors of justice. At the conclusion of this case, we ask that the motion is denied. Thank you.
Thank you. Defense, are you ready to call your first witness?
Yes, Your Honor. We would like to call Charlie Nguyen to the stand. May I proceed?
You may.
Good morning. Please state your name for the record.
My name is Charlie Nguyen.
And what is your occupation?
I'm currently a licensed investigator and the sole operator and proprietor of Nguyen Investigations Incorporated.
And how long have you been in your position?
I've been a private investigator for nearly 10 years now.
How many cases have you worked on as a private investigator?
In my time as a private investigator, I'd say I'm working over on nearly 100 cases.
What did you do prior to your time as a private investigator?
Prior to becoming a licensed private investigator, I was a police officer for the Buckeye Police Department.
And what was your training for these positions you've held?
Well, I started out at the Buckeye Police Department as just a patrol officer where I'd respond to citizens' calls and do routine traffic patrols. But I knew I eventually wanted to become a detective. So I started taking a lot of advanced training seminars and classes on criminal investigation. At that point, I even took classes on specific types of evidence like DNA evidence and dusting for fingerprints and how to analyze that evidence. And all of that led to me eventually becoming a detective and a certified evidence technician with the Buckeye Police Department.
A certified evidence technician seems like a fairly important job. Would you tell us what they do?
Yes, of course. A certified evidence technician, when there's a crime, the responding officer will call a certified evidence technician to collect the evidence. So I might dust for fingerprints, collect DNA samples, retrieve fibers, retrieve surveillance video, take measurements. It really varies depending on what the responding officer needs at the time.
And what was your training on interaction with witnesses?
Also, while at the Buckeye Police Department, I received training on the fundamentals of interviewing witnesses and suspects, and on the fundamentals of criminal investigation, and keeping an open mind while reviewing evidence. So just general criminal investigative procedure.
Your Honor, at this time, I would like to admit this witness as an expert in forensic analysis, witness interrogation, and crime scene evidence due to their established specialized knowledge, skill, experience, training, and education in this field.
Is there any objection from the state?
Yes, Your Honor.
Explain more.
I do not feel that they have the educational, they do not have enough education to be considered an expert witness.
I'll overrule that objection.
Thank you, Your Honor. May I proceed?
You may.
How did you find out about this case?
On October 2nd, 2019, I received a call from Micah Opusay's defense attorney, Freddie Sticks, and he said he was representing a young kid who needed who was accused of murdering his best friend, I guess. And he wanted me to review the evidence that the prosecution had against him.
So you said you were asked to review evidence that was previously disclosed. What did you see listed in the discovery you received?
I received the discovery from the state, and I saw 5 key pieces of physical evidence. First, I saw a fingerprint retrieved from Hamea's glasses that the state alleges belongs to Micah Opusay. Second, there was a shoe print that could be consistent with Micah Opusay's shoes that he was wearing that night. Third, there was a fiber that the state alleges belonged to Micah Opusay's jacket. And then fourth, there were angry text messages. Some angry text messages from Micah to the victim, Hamea Robbins. And finally, there were some posts on social media that the state alleged were mentioning betrayal and revenge and could have been directed at Hamea Robbins.
Was there anything else listed in the discovery?
Beyond that physical evidence, there was an eyewitness account from a witness named Corey Abrams, who said Micah Opusay was the person he identified as fleeing the scene.
Your Honor, let the record reflect I am showing opposing counsel a clean and unmarked copy of Exhibit D and E. At this time, can I present Exhibit D?
You may.
Are you familiar with this exhibit?
Yes, this is the fingerprint analysis that was found in the discovery report.
Would you explain to us what you see in this exhibit?
Well, I see obviously the 2 comparison matches that they compared. I see the latent print that was taken from the victim's glasses and Micah Opusay's print on record, the comparison print. But a couple things, one thing that jumped out to me as soon as I saw this is there's only 7 matching points that they found, yet they call it high confidence. However, I dispute that. In a full fingerprint, there's 150 points of match. So when analyzing a fingerprint, they look for points of match, and in this circumstance, I only see 7, which I don't believe enough is to make a high confidence match.
Could you explain to us what a minimum requirement could possibly be?
Well, let me explain a bit of how fingerprint analysis is done, which will help understand that. There's 4 key steps. First, they analyze the fingerprint to see what the evidentiary value and whether they can do a comparison. Second, they compare to compare the recovered print to a known print that they have. And finally, the third step is they evaluate the fingerprint to see if it matches, it's an inconclusive or it's an exclusion. And then the final step, and perhaps most important, is the verification, where they have a second examiner verify the results of the first. So that's called the ACE-B methodology. It's the most commonly used. So when doing that in the comparison stage and evaluation stage, I've never seen less than 12 points be used to make a match. So 7 points in this circumstance, I've only seen nearly double that used to make a match. So that jumped out to me. 7 points did not seem enough to make a match between that print recovered and Micah Opusay's known print.
And could you tell us again why it's important that a second examiner reviews this match?
A second examiner, there's a lot of subjectivity involved in the process. And when I looked at the discovery report, I saw that there was no mention of a second examiner reviewing this evidence. And I think if a second examiner saw this, they would certainly dispute that it belonged to Micah Opusay because there were only 7 points. And with the subjectivity involved in the process, the verification step seems to have been overlooked, and it very possibly could have resulted in malpractice on this evidence.
So we now know about the fingerprint, and you mentioned the shoe print that was in the discovery. Could you turn your attention to Exhibit E?
Of course.
Are you familiar with this exhibit?
Yes, this is the photograph of the shoe print that was found in motor oil near Hamea Robbins' body.
And could you tell us what you see in this exhibit?
Well, the first thing I see is that, more what I can't see. In the discovery report, it didn't note whether this photograph was actually taken at a 90-degree angle, which is necessary for determining whether what the actual size of the shoe is. So in this circumstance, I can't tell you for certain it's a size 9 shoe. The discovery said it is. It does appear to be consistent with Converse shoes. It does be so from if it was taken properly, it will be a size 9 Converse shoe.
And you mentioned what they need to do to ensure that this is collected properly. Could you tell us again what they need to do?
Yes, they need to take it pretty much a perfect 90-degree angle, and they need to make sure that because there's a lot of room for error in that. If it's not done perfectly, there's not much difference between shoe sizes. So without that being done, and there's no note that that was done properly, so I can't tell you for certain it's a size 9 shoe.
And what are your thoughts on the shoes and size matching up to Micah's?
Well, my thoughts are it doesn't really say anything about Micah Opusay. I'm sure a lot of people wear size 9 Converse shoes, even in the town of Harmony. So just because a size 9 Converse shoe was found in one of the most popular food truck locations in Harmony in some motor oil, which could have been there for a long time, doesn't really connect Micah Opusay to any sort of crime.
So we know about the fingerprint, and now we know about the shoe print. Can you tell us about the blue fibers you mentioned?
Of course. There was the third piece of actual physical evidence that was noted in the discovery report was a blue nylon fiber recovered on the body of Hamea Robbins.
And could you tell us about your thoughts on possibly when this fiber could have been found?
Well, first, I thought there's no way to know when that fiber was put there. It could have been, or how it was put there, for that matter. It could have been transferred to Hamea's body long before her murder, while she was alive and interacting with anyone. And any sort of physical contact could have transferred that fiber, not necessarily a murder.
And could you explain to us the possibility of these fibers matching up to Micah's bomber jacket that his description matched?
Yes, Micah was described as wearing a blue bomber jacket that night, but this is just a blue nylon fiber. We don't know what it came from. And nylon is one of the most common fibers found in clothes. Anyone wearing blue clothing, like I'm wearing a blue tie, if I came near Hamea Robbins, this blue tie could have transferred a nylon fiber to her body. That doesn't mean I killed her. So anyone could have transferred that. It could have been transferred at any time and really in any way.
And you have explained to us each individual piece of evidence. Could you tell us your thoughts when putting the material evidence together?
Looking at the material evidence alone, it's all really circumstantial and doesn't point to Micah Opusay at all. Even taken as a whole, there's not really much evidence against Micah Opusay in this case, taking that physical evidence alone.
And if there was anything to link Micah Opusay to this case, could you tell us what that may be?
The main thing I saw was the eyewitness account. That was really the linchpin that brought all that evidence together and said Micah Opusay was the person who committed that crime. This evidence could have supported that conclusion, but I think without that eyewitness testimony, you can't say anything about Micah. You can't even determine that Micah Opusay was even at this location, let alone he's the one who committed this murder.
And what are your thoughts on the validity of this eyewitness statement?
The eyewitness statement, which now apparently has been retracted. At the time, I had doubts about the eyewitness statement because, one, it was getting dark in Harmony at that time. It was in late fall, so it gets dark early. And so I didn't even, it could have been getting dark. Usually when eyewitnesses are making identifications, they can be taken from quite some distance. Like in this case, I think it was 20 yards, and it's obviously not ideal conditions. And I also think the way the eyewitness identification was done was improper.
And how was Micah identified in this case?
Micah was identified using a 5-photo lineup, which is still fairly common. However, I don't think 5-photo lineups have a lot of issues, which could have tainted the eyewitness account originally.
You mentioned issues. What are some issues with this type of identification?
5-photo lineups, it's where a detective presents 5 photos of people with similar characteristics matching the description of the eyewitness matching the description. And in this circumstance, they're presented 5 photos. But one of the main issues is if you're presented 5 photos and an officer of the law tells you to pick someone from these 5 photos because they think they committed a crime, then you're going to pick one of them. Most likely, even if they don't at all resemble the person you saw, they only somewhat resemble them. So I think that could have been the issue in this case. He was presented with some photos and one of them could have maybe somewhat resembled them, but there's a lot of pressure involved. So, and clearly Corey Abrams didn't think the person that he identified was actually the person he saw when looking back on it.
And what actions did you take regarding this eyewitness?
Well, I really wanted to get in contact with Corey Abrams, so because again I had doubts even before he retracted his statement because of how important his testimony was. So I attempted to call him, but sadly he never called me back. I didn't want to bias him in any ways or prejudice him, so I didn't say what I was calling about. I just left a voicemail saying I was a private investigator and I'd love to get in touch with him, but he never got back in touch, and I was under a time crunch, so I really didn't have another opportunity to get in contact with him, sadly.
Mr. Nguyen, in your expert opinion, how does this evidence implicate Micah Opese as a murderer?
This evidence, when not considering that the eyewitness testimony has been retracted, the physical evidence alone doesn't implicate Micah Opese as the murderer. All it does is show someone with a maybe similar fingerprint type to Micah Opese, possibly a shoe size, similar shoe, and someone with similar clothing may have been in the area of the food truck, which we know happened. Micah admitted to being in the area, but it doesn't say anything at all about him killing Hamea Robbins, just that he may have been in the area, and it could have been anyone who left those things at any time, again, as I said. So that physical evidence alone doesn't say anything without that eyewitness testimony.
Thank you, Your Honor. No further questions at this time.
State?
At this time, I would like to cross-examine Charlie Nguyen.
Yes, go ahead.
Thank you, Your Honor. Hello, Charlie Nguyen. I'm Carolyn Rinaldi, one of the prosecution witnesses. Your Honor, may I proceed?
You may.
You were the private investigator hired by Micah's lawyer, right?
Could you, sorry, there was some background noise. Could you repeat
Yes.
that?
You were the private investigator hired by Micah's lawyers, right?
Yes, I was hired by Freddie Sticks, Micah's defense attorney, to review the evidence in this case.
Thank you. And you were hired to do this job for more than your normal rate, right?
As I said on direct, there's an extreme time crunch here. The trial was coming up quickly, and Freddie needed evidence reviewed fast. So he came to me, and he offered to pay me double. He did offer to pay me my double my normal fee because of the extreme time crunch, so I could get to work immediately.
Thank you.
Reviewing.
So you would say because of those reasons, and because of the circumstances, a major reason that you did take the case was a significant increase in your pay?
Well, I mean, I own my own firm, so I have to get paid, but I mean, obviously, that doesn't affect how I review the evidence. I reviewed the evidence objectively in this case. I take exception to any notion that I didn't because of my
I'm sorry,
over
was
25
that a
years.
yes or a no?
I didn't take it solely because of the money, but yes, I have to run a business, so that was part of the equation.
Okay, thank you. And you said in your sworn statement that you were hired to review the evidence and talk to the prosecution witness, right?
That's what I was hired to do. Yes,
And
I was
all the
hired to-
evidence and information that was of the case was all given to you in a file, correct?
Yes, I received a discovery report that listed all the evidence the state had against Micah Opese.
And in the evidence you reviewed, you saw partial fingerprints lifted from Haumea's glasses, correct?
Yes, as I discussed, there was a partial fingerprint lifted from Hamea's glasses.
Thank you. And the fingerprints you found on the glasses were in the fingerprints that you reviewed from the glasses were an arch pattern, correct?
Yes, those fingerprints.
Just the yes or no is okay. And the arch pattern makes them the rarest type of prints. That only makes up 5% of all pattern types. Is that right?
Arch patterns are the rarest type. While it only makes up 5% of the world, 7% of the population of Buckeye has that, which equates to over 800,000 people.
But you would agree that 7% is still rare, wouldn't you?
It's rare, but taking into account the large population of Buckeye and Harmony, it's still a whole lot of people.
So that was a yes?
Yes, it's rare. I don't dispute that now.
Thank you. And you said that you have never seen less than 12 points of identification for a fingerprint match. Is that right?
No, in my 25 years of experience, I've never seen less than 12 points used now.
However, you are aware that there is no standard for how many points of identification are needed to make a match in the United States, correct?
There's no national standard, no, but I think good procedures are universal. If you're going to make an identification with the implications that someone killed someone else, so murder, you need to have a high standard for determining that fingerprint belonged to that person.
But that was a yes?
There is no national standard, no.
Thank you. In the footprints in the lot that matched The footprints in the lot match the same size and type of shoe that Micah had admitted to been wearing that evening. Is that right?
Oh, it's probably one of the more common shoe types, and who knows when it was left there, but it did match Micah's shoe size and type. But she admitted in the place he admitted to being, yes.
And there was a size 9 Converse shoe, correct? That's what it was?
I can't confirm it's a size 9, but the discovery report, the Harmony Police Department did claim it was a size 9, yes.
So you stated that you aren't certain that the crime scene technicians followed an exact procedure to produce that 90-degree photo of the shoe print. Is that correct?
It wasn't noted in the discovery, so no, I can't be certain.
However, you cannot testify today that they did not follow that protocol, right? You're not 100% sure.
No, I'm not sure they didn't follow the protocol, but again, it wasn't listed in the report that they did.
Okay, and you said in your sworn statement that there are about 4 things you might do as an investigator in a criminal case. Is that right?
Could you clarify that? What do you mean 4 things I might do?
Yes, you said that 1 would be going to the scene of the crime and look at the evidence. 2 would be to review physical evidence that has already been collected. 3 is to talk to the witness, and 4 is to find new ones. New witnesses.
Those are the general, yes. Those are the general steps involved in a criminal investigation, yes.
Thank you. However, in your preparation for the testimony today, you did not talk to any witnesses, is that right?
I tried to, but I was under an extreme time crunch and never was actually able to get in contact with the witness, despite me really wanting to talk to him because of how important his testimony was.
And you did not try to find any new witnesses?
No, there were no new witnesses noted in the report, and I had a lot of physical evidence to review. I didn't, and no other witnesses were noted, so I was not able to track down anyone new, no.
And in your preparation for today's testimony, you never visited the crime scene, right?
I don't recall actually visiting the crime scene. It's been over a year, but I reviewed all the physical evidence very thoroughly, which was analyzed by the crime lab, and I already explained my objections to that evidence.
Okay, and just to summarize, you did not do everything that you said as an investigator you would do to be thoroughly prepared for a trial. Is that right?
Well, again, there was an extreme time crunch. I had, I think, only 5 days between when I was called on and to complete the trial. So I didn't have time to take all the steps that I listed there. So I focused my time on making sure I got accurate analysis of what I had. And the crime scene at that point.
So is that a yes?
I wasn't able to follow all those exact steps specifically, but I followed the steps that I believe best allowed me to analyze this evidence.
Okay, thank you. No further questions.
Thank you.
Thank you. Any rebuttal?
Yes, Your Honor. May I proceed?
You may.
Mr. Nguyen, how long did you work on this case?
I received my call on October 2nd, and the original trial date was set for October 7th. So I had to have my review done in that short 5-day time frame. And a regular criminal investigation takes much longer. And so in that short time frame, that's why I was paid. Again, that's why I was paid more, because of how quick that time frame was. So I didn't have a lot of time to review the evidence, and I sadly wasn't able to do everything I'd like to do, but I believe I did enough to get a solid analysis of this evidence. And
you told us earlier that what you're needed for in a call depends on what your call is. Can you tell us what you're needed for in this case?
Yeah, I work for someone else in this case. I think that's clear. I'm a private investigator. I don't work for the state. So I do what I'm paid to do, and in this case, I was paid to review the discovery, so that's what I did. I wasn't asked to go find new witnesses, which certainly might have helped Mike Opus's case, but I wanted to make sure I followed my contractual obligations, and I reviewed the discovery, and now I'm testifying here today about what I think about that report.
And the prosecution mentioned the fingerprint. When reviewing the fingerprint, can you tell us what flaws you found in your expert opinion that were made in the identification of the matching print?
Again, there were 2 big flaws. One, which are almost related. One, they only found 7 points, which is almost half of what I've usually seen. The lowest I've seen used to make an identification, which is 12, even though it was a partial fingerprint. And 2, there was no verification step, and it's a very subjective process. So without that verification, we can't be fully confident in that matching.
And could you also tell us again how conclusive this evidence was in pointing to one person?
The physical evidence alone, which is now apparently all we have, wasn't conclusive at all in pointing to one person, especially even regarding murder. It doesn't point, all the evidence alone and taken together doesn't indicate any one specific person as even being there or killing Hamea Robbins.
No further questions, Your Honor.
Thank you. Any recross?
Yes, Your Honor. Because of the time crunch, you said you weren't able to do everything that you wanted to do in preparation for this case, even though you were still being paid double. Is that correct?
Well, being paid double doesn't create more time. I used all the time I had to review the evidence and did what I was paid to do, and I reviewed the evidence solidly and objectively.
Objection, Your Honor. Beyond the scope of recross and pursuant with Rule 611.
Witness already answered the question, so I'll allow it.
Okay, thank you. No further questions.
Defense, do you have your second witness?
Yes, Your Honor. The defense would like to call Corey Abrams to the stand. May I proceed?
You may.
Good morning. Would you please state your name for the record?
Corey Abrams.
What do you do for a living?
Well, I run a food truck in downtown Harmony that sells Israeli street food. Corey's Kebabs. We sell falafels and, of course, kebabs. However, over my 5-year career, I've never witnessed a day quite like August 31st.
Tell us more about what happened that day.
Well, I was in my food truck and I was scrubbing my grill around 8:30. And I thought what I heard was just a truck backfiring. And then I saw someone running across the parking lot around 20 yards away.
Who was this person?
Well, it was dark out and I only saw them for like 10 seconds. I saw a glimpse of their face when I said, "Hey, what's going on?" They were wearing a blue bomber jacket and they were carrying a gun, so I didn't try to follow them.
What'd you do next?
Well, since I couldn't try to follow them, I called 911. Detective River Foley came before too long at the scene and asked if I've seen anything. We had a conversation and I ended up giving them my phone number.
So you gave Detective Foley your number. What happened with that?
Well, it's been a few days since anything really happened. On September 2nd, Detective Foley called me and asked me to come in to see if I can do a photo lineup and see who I saw running. But I was at a food convention in Chicago all week.
What happened after the convention?
Well, the convention ended on the 9th, but I came back on the 10th. And as soon as I came home, I went to Detective Foley to give a photo lineup of 5 people, but it was a little difficult.
Why was it difficult?
Well, all the pictures looked familiar and a little bit similar. And it's been over a week since I actually saw the situation. And I mean, I do have a good memory for events and especially a good memory for faces too. You have to have a good memory for faces when you're in a food truck, you know. Anyways, I picked the person I thought I saw running.
Well, why did you pick it?
The photo did seem a bit brighter than the others, and Detective Foley was hovering around me, watching me very closely while I was trying to pick them. I told them I wasn't completely sure what happened, this was the person, but they seemed relieved, like I did a good job. But yeah, I did a good job. And I was,
Well, what happened after the photo lineup?
well, about a month went by on October 6th, and I sat down to watch the news, and they were talking about a recent murder in Harmony, the one by my truck. And they said that the person that I implicated, Micah Opessa, was getting arrested. And that is when I realized that they weren't the one I saw.
Well, how did you know you were wrong?
Well, when I saw him and I knew that picture looked familiar to me. It was because I saw them earlier that evening. And when I saw them walking around in broad daylight, I knew that I was wrong.
How did you feel about that?
I was absolutely devastated. My heart sank when I saw Micah getting arrested. And because of me, this wrong person is getting the jail.
It's okay, Miss Abrams. If you could, would you tell the court what happened afterwards?
Well, after I saw Micah on the news, I called Detective Foley. And then I told him and explained what happened, but they thanked me and they didn't call me after that.
Did you contact anyone else after that?
Well, after my call, I didn't know who to call next. And I Googled the number to the Cardinal County Prosecutor's Office. And I asked them why no one ever got back to me after my call, but she never really answered my question. She said that she'd add a little note to the case file, and I asked if anyone would get back to me, but she said she wasn't sure.
And did anyone get back to you?
No, I thought they just dropped the case. Instead, I found out that Micah was going to prison, and it's all my fault because of me. And when I called back the prosecutor's office, and the clerk that I talked to the first time wasn't even there anymore.
Well, after Michael went to jail, what'd you do?
I felt terrible. Almost a year passed, and I spent it all feeling horrible. I lost sleep. I lay awake thinking about this kid rotting in prison because of me. And oh my gosh. Just the thought of it just makes me so mad that I picked the wrong person. And I would never say under oath that they were the person that I saw running the parking lot that night. So bad.
It's all right, Miss Abrams. It's not your fault. You did everything you could. Would you please tell the court what you did during that year?
Well, on September 10th, I sent a letter to Micah's attorney explaining everything and offering to help. And I guess that's why I'm here today. But I remember way back in October that I got a message from a private investigator that they called me, and I never remember getting any messages. I just really hope my voice is heard.
Thank you for your time, Miss Abrams. No further questions, Your Honor.
Thank you. State cross-examination?
Yes, Your Honor. You are the owner of Corey's Kebabs, correct?
Yes.
Your food truck is located downtown Harmony on the corner of First and Green, correct?
That's correct.
You were at work the night of August 31st, 2019, correct?
I was scrubbing my grill, yes.
The night of August 31st, 2019, you told police while you were getting ready to close, you heard what you assumed to be gunshots, correct?
I thought it was just a truck backfiring.
You then saw someone running away with a gun, correct?
Yes.
You got a pretty good look at their face and build, correct?
I just saw a glimpse because it was so dark outside. I only saw them for 10 seconds.
You then proceeded to call 911, correct?
Yes, since I could not follow them.
Detective River Foley then approached you and you proceeded to tell them your account of what happened, correct?
Yes.
You then gave your contact information, correct?
Give them my phone number.
2 days later, on September 2nd, Detective Foley contacted you regarding a request to conduct a photo lineup, correct?
Yes.
September 10th, only 10 days after the incident, you went down to the station, correct?
When I came straight home from the convention, yes.
You were given a photo lineup with 5 individuals, correct?
That's correct.
You picked the photo of the person you thought you saw running away.
I wasn't completely sure, but they did all look similar, and the one that looked really familiar to me, I picked.
After the photo lineup, nearly an entire month went by and you didn't think much about the case, correct?
Well, I thought that I had done my part, that I contacted the police, I came into the photo lineup, and that I thought that I picked the right person, but it turns out I was wrong.
On October 6th, you were watching TV when you came across the arrest of Micah Opusay, correct?
Yes.
Nearly an entire month later, when you saw the video of them getting arrested, you were certain that you picked the wrong person during the photo lineup, correct?
Yes.
In your statement, you stated that you have a pretty good memory for faces, correct?
I have to since I run a food truck.
Also in your statement, you stated you've gotten a lot of practice remembering faces and details, correct? In the beginning, you were certain you made the correct identification. After you saw the news, you were certain you were wrong?
Well, in the photo I had, it was just a photo, just a still picture of a suspect. But when I saw them in the video surveillance, I got to see the way they walked in broad daylight.
Micah Opusay isn't as tall or built like the person you say you thought you saw running away that night. Correct?
I'm not for sure.
In your statement, you stated that once you thought about it, you did recognize Opusay's face, correct?
Yes, because I did see them earlier that evening ordering a food truck.
No further questions.
Any redirect?
Yes, Your Honor. What did you think you heard on August 31st?
I thought it was just a truck backfiring.
Did you get a good look at the person running away?
No,
Why did you pick the photo of Micah Opusay?
they looked familiar to me, and it was a little bit brighter than the other pictures.
And why did you change your mind?
It's because of what I saw in the news when I saw him actually getting arrested, in the way, like, I got to see his whole like body figure and everything about him, like his face and the way he walked.
Thank you, Your Honor. No further questions.
Any recross?
No, Your Honor.
Thank you. Defense, do you have any further witnesses?
Not at this time, Your Honor.
State, are you ready to proceed?
Yes, Your Honor.
Please call your first witness.
I would like to call Justice Okafor. Hello, my name is Italy Simmons for the prosecution. I will be conducting the direct examination of Prosecutor Justice Okafor. Your Honor, may I proceed?
You may.
May you please introduce yourself?
My name is Justice Okafor.
And what do you do for a living?
I work for the prosecutor's office in the General Division.
What is your position at the General Division?
I'm an assistant county prosecutor.
And what about your educational background?
I graduated from Buckeye State's DeHaan School of Law in 2010.
How long have you been involved in this profession?
Since I graduated from law school, before I even passed the bar.
And roughly how much is your active docket?
I usually have anywhere between 60 to 80 cases, all of which are adult felonies.
Is that a difficult amount to manage?
Some prosecutors may believe that it's a stressful amount to manage, but that's just how things function in our line of work. It's part of what we do, and having this many cases is just something I went to school to be prepared for.
Now regarding the case itself, when were you assigned to Opusay case file?
I believe in the September of 2019.
And do you recall this case?
Oh yes, I had been familiarizing myself with the case, and once I had read it all over, I decided that I wanted to bring the case.
And what type of evidence was a part of the case?
There was an in-depth crime scene summary, which had very hard physical evidence to get.
May you explain what crime scene evidence summary stated?
Well, there's a shoe print, a fiber matching the jacket Opusay was wearing, a partial fingerprint on the victim's glasses, and all of this physically put him at the scene.
And was there anything else in the case file?
There were also various threatening and concerning posts and texts made by Opusay.
Your Honor, I'd like to screen share what has previously been stipulated to and marked as Exhibit B.
Go ahead.
Can you see my screen?
I can see your screen. I don't see exhibit. Oh, you're grabbing it.
Let the record reflect that I am screen sharing a clean and unmarked copy of Exhibit B to opposing counsel. Ms. Okafor, can you identify this exhibit?
Yes, I can. This is a tweet made by Micah Opusay.
And are you familiar with this exhibit?
Oh, yes. As part of investigations, we're accustomed to going through the accused's phone. During this process, we found many incriminating social media posts, one of which is this Exhibit B.
And can you describe the exhibit?
This is a threatening Twitter post made by OCLRE on August 9th and 10th of 2019. OCLRE alludes towards the victim being in pain and how OCLRE wishes that upon them.
Thank you. Was there anything else?
Speculation, or, yes, speculation.
I'm sorry, could you repeat yourself?
Objection, speculation.
State, do you have any response?
Yes, I believe that this is not speculation. If you read it, you can clearly tell that he is expressing his greed.
Any response from defense?
The Justice Okafor cannot attest to who these tweets are directed towards.
Also state that objection.
You are.
Thank you. Was there anything else?
I believe the last piece of evidence was a photo lineup identifying it.
And when was that identification made?
It was made on September 10th of 2000.
And who was the eyewitness?
The identification was made by Corey Abrams, a local food trucker.
Earlier you mentioned that this situation was basic. Could you explain why you see it in that way?
Well, all the evidence built a
Opinion?
Could you repeat that again?
Proper opinion?
Say more.
Justice Okafor cannot give her opinion on she's not an expert, she cannot give her opinion on a piece of evidence.
Defense, any response?
It's not particularly her opinion. It is what she deals with, and it is 90% of her cases that she has. So she is actually stating the fact.
Overruled. Proceed.
like I was, all of the evidence built a story that was a prime example of, as mentioned earlier, 90% of all adult felonies. And the fact pattern is crimes sparked by strong emotions. In this case, the strong emotion was a love triangle.
And what did you learn after reading Kai Robbins' account of the relationship between Opusay, Haumea, and the third-party individual?
I learned that their relationship was quite rocky, actually. Their group was very close, but Opusay started to develop feelings for Haumea. Haumea did not return those feelings for Opusay, but for...
Can you state the basis again?
Speculation?
Say more.
Justice Okafor cannot attest to Micah Opusay's feelings or Haumea's feelings.
Defense, response?
It is clear that Haumea did not return those feelings for Micah, which is why she proceeded to get into a relationship with the third-party individual.
I'm going to sustain that objection.
When was the preliminary hearing?
It was on September 20th, 2019.
And what was the outcome of the hearing?
Well, the court found enough evidence to be able to continue on with this.
After the preliminary hearing, what did you do?
Well, I had a conversation with Opusay's attorney, Mr. Singh. We talked about if there would be a plea offer.
And what was the plea offer he asked for?
Well, I told him that there was quite a bit of Opusay. I made a plea for murder 2 and for 30.
And was this plea accepted?
No, it was rejected, and I continued to prepare for this.
And is this a thing that usually happens?
No, it's a little unusual, I would say.
How is it unusual?
Well, starting a plea negotiation before discovery is not something I see every day, but because no discussion has really even started between the two sides.
And what impression did this make on you?
It showed some lack of confidence, but I never really thought.
And are pleas common?
Oh, yes, actually. Many people don't realize that most criminal cases end in a plea bargain.
During this case, 2 plea offers are made. What was the first plea offer?
Well, it was, like I said before, second-degree murder for 30.
And when was the first plea deal turned down?
It was turned down September 20th of this year.
And after the plea deal was turned down, when was the trial scheduled for?
I believe it was October 7th.
And did the trial move forward on that date?
Oh no, I asked for a continuance.
Why?
I wanted to get all of my facts in line for a plea offer I was going to offer to Opus Dei. After reviewing the case file with fresh eyes, I realized that the ample evidence made the outcome of this case obvious. I could offer Opus Dei a great deal because they had a relatively minor, simply like that, just to be fulfilled.
And what was the next discussion you had regarding the Opus Dei case?
While I was going to request that continuance, I ran into Detective Foley.
And may you tell us what you discussed?
Well, Detective Foley informed me that Abrams, the eyewitness, was having some reservations about their identification of the defendant.
What did you proceed to do after you were told this information?
I took note of this information. I asked the law clerk to follow up with Abrams, and I reviewed everything that they found. Abrams was indeed unsure about their ID, but it didn't impact me much because the ID wasn't too important to us from the beginning.
And did this case proceed normally?
Oh no, later I did offer that new plea deal.
And what was the new plea offer?
It was voluntary manslaughter for 10 years in prison.
The defense wasn't made aware that the witness withdrew their identification. May you explain why?
I have no idea why the defense did not interview the witness. It's usual for depositions to be formed on both sides, but in this case, for some reason, it never happened. I even gave them a list of the witnesses, and they had weeks to talk. I made the decision to call the testimony ineffective to the outcome of the case. An eyewitness is just so unreliable. And my case hadn't been relying on the ID from the start. We had a strong case, and we still do. So I dismissed it.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor.
Good morning, Justice Okafor. After the preliminary hearing, you learned that Opus Dei was opposed to a plea deal and passionate about their innocence, didn't you?
That is what I learned, yes.
You then marked down a trial date and got to work on another case, didn't you?
Oh yes, I had many other cases on my docket.
Now, over the next 11 months, you tried a lot of cases, right?
I believe 15 to be exact, yes.
Yeah, 15 cases. Those 11 months were pretty tough for you. Out of those 15 trials, 5 ended with defense verdicts and 1 with a hung jury, right?
Yes, I believe those are the statistics.
In fact, one of these trials had an article written about it, right?
Oh yes.
Objection relevance.
Defense response?
I believe it is relevant. The article, as I will explain, was about trumped up charges, criminal justice reform. I feel it demonstrates a precedent for Justice Okafor's behavior and why she's here today.
Okay, I'll see where this goes. State, feel free to renew your objection.
All right, may I proceed?
You may.
In fact, one of these trials had an article written about it, right?
Yes.
It was about trumped up charges in criminal justice reform, right?
Yes, I believe it was about one of the cases, like you said, trumped up charges, and it was disturbing to me.
So you dismissed it as nonsense, didn't you?
Of course, I thought it was nonsense. As a prosecutor,
Objection relevance.
Defense response?
I am still establishing the precedents for behavior.
I'm going to sustain that objection.
All right, thank you, Your Honor. May I proceed?
You may.
Now, when Opus Dei's trial rolled around, you requested a continuance, right?
I did request a continuance.
You then offered Opus Dei another plea deal, didn't you?
Yes, I requested the continuance for that exact purpose.
And you'd seen Freddie Stix's work before, hadn't you?
Oh yes, I'd seen them a few times in trial.
You don't usually offer plea deals because you enjoy trials, right?
I do enjoy trials.
You also said you were impressed by Stix's courtroom skills, right?
Yes, of course, like I said before, seen him in court a few times, and I know how he can raise sympathy from a jury.
In fact, when reviewing the Opus Dei case file, you commented that Stix would likely use Opus Dei's minor criminal history, personal details about Opus Dei, testimony from a private investigator to defend Opus Dei, and the jury might be swayed in the defense's favor. Did you not?
Yes, like I just said, I seen how before they could raise sympathy in the jury, and I respect that.
All right, well, to clarify, you had been having trouble getting prosecution verdicts, and when presented with a competent defense attorney who had the opportunity to effectively defend their client, you, a prosecutor who rarely offers plea deals and who enjoys trials, decided to offer a second plea deal. Am I correct?
Yes, I do not believe the context in all of in that re-summary was not how I would have stated some of course, the context. But yes, I do believe in a way that re-summary could restate some of my past.
Moving on, you knew from Detective Foley that the prosecution's eyewitness had been having reservations about their identification of the defendant, didn't you?
Oh yes, I was informed when I was going to request the continuance. I ran.
All right, well, in fact, you learned that the eyewitness was no longer sure that Opus Dei was the person they saw the night of Hamea's death, right?
Yes, I was informed that there were some reservations.
So you claim that Stix had time to follow up on Abrams if he wanted to, correct?
I'm sorry. I don't think I understand your question. Can you rephrase?
You claim that the defense attorney had the time to follow up on Abrams' testimony, right?
Yes, of course.
But you were the one who was told Abrams recanted their testimony, right?
I was told, and I'm not sure why they did not figure it out themselves.
Now, you say eyewitnesses are generally unreliable, right?
Yes, I would stand by that statement.
So you made your own judgment call, didn't you?
Yes, I made a judgment call for my case.
You surmised that,
unreliable.
you surmised that this didn't affect the case, didn't you?
Oh, yeah. Like I just said from the beginning, I assumed it was unreliable. It wasn't strong in my case, at least.
Well, instead, you just offered another plea deal, didn't you? Easy, no trial, sentence served. You just offered another plea deal?
Yes, I offered.
Objection, speculation.
Objection overruled. Please answer the question.
Instead, you just offered another plea deal, didn't you?
I did offer another plea deal, which is why I was requesting a continuance. That's when I found out about Abrams' reservations. Yes, I did offer another plea deal.
Justice Okafor, the original plea deal was a 30-year sentence, right?
That was the original statement, yes.
But after learning the eyewitness recanted their statement, you offered a new plea deal, which was a 10-year sentence, right?
I came up with that plea, yes, before I knew about the reservations.
You claim that the eyewitness testimony doesn't affect the case. It's no big deal, but that's a 20-year difference, right?
Yes.
Well, I mean, that gap is longer than Opus Dei himself has been alive. Given that, can you truly say the eyewitness had no effect here?
Yes, I can.
Well, I suppose we'll just have to let that speak for itself. No, thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. Did the witness having a reservation have any relation to you offering a new plea deal?
Oh, no, it did not. In fact, I came up with the plea deal before even I had even learned about Miss Abrams' reservations, like I think I stated many times. But yeah, did not.
And due to your profession, is it your job to notify defense about witness reservations?
No, it is not, and I'm not too sure why they never re-interviewed the witness before the trial.
And also, are plea bargains common once again?
They are common.
No further questions.
Any recross?
Yes, Your Honor. You were told Abrams recanted their statement, right?
Yes. Well, not recanted. I was aware they were having reservations.
And you don't usually offer plea deals, do you?
Not all the time, no.
But you did this time.
I did.
Thank you, Your Honor. No further questions.
Thank you. State, are you ready to call your second witness?
Yes, the prosecution calls River Foley.
Thank you. Go ahead.
Okay. Please state your name for the record.
I'm sorry. A little bit of technical difficulties.
No, you're fine.
Would
Go
you
ahead.
like
Could
to
you
state
ask that question again?
Yes. Please state your name for the record.
My name is River Foley.
Are you currently employed?
Yes, I am a detective.
Where?
I am a detective for the Harmony Police Department.
And how long have you worked there?
I've been a police officer for the past 24 years.
And what got you interested in becoming a police officer?
Well, after my service in the Gulf War, I knew I wanted to continue to help people, and becoming a police officer would allow me to do just that.
And when did you officially become a police officer?
Once I was done with my initial training, I was hired in 1996.
Where did you complete your training?
Buckeye Police Officers Training Academy.
And what was your first position as a police officer?
Well, I began as a patrolman, and then in late 2000, I was offered a promotion.
What was that for?
Investigator training.
How long was your training?
Well, I had been in training for 3 months, and during that time, I completed more than 300 hours of training.
And what was the result of your training?
Humbly, I must say, in 2002, I earned the Master Evidence Technician Award.
Wow, very impressive. And when did you officially start working at the Harmony Police Department?
It was in May of 2003 where I was assigned to the homicide unit.
And what did you specialize in?
Well, also, about 2 years into my career in 2005, I also completed training with the FBI in advanced criminology.
During your training with the FBI, what did you specifically work on?
Well, I was working on and learning the proper techniques for collecting and preserving evidence, which includes fingerprints, blood samples, shoe prints, and material facts.
How many cases would you estimate that you've worked on?
Over 400 cases.
And do you recall the night of August 31st?
Yes, very clearly.
What happened that night?
Well, I was at home watching the Great Harmony Bake Off. Then I received a call.
Who called you?
My boss.
And why did they call you?
They received a call about a homicide.
What did you do after receiving this call?
I went to the scene immediately.
Once you got to the scene, what did you observe?
Well, I noticed someone closing up their truck and went over to talk to them.
And who was that?
Their name was Corey Abrams, the owner of Corey's Kebabs.
Back to that night, did you have any interaction with Corey Abrams?
Yes, I went over after arriving at the scene to talk to her.
And what did you learn from your conversation?
Corey Abrams heard a gunshot and saw a figure running across the lot with a gun.
What happened next?
I took her statement.
What did you do after talking to Abrams?
I walked over to where the homicide was committed.
And where exactly was the homicide committed?
In the parking lot at the corner of First and Green.
Are you familiar with this area?
Yes, I have worked multiple patrols in the area, and I'm guilty of having my favorite food truck, Bacon Me Crazy, being located there.
And what was happening when you arrived at the scene?
At this point, the coroner had already removed the body and the crime scene investigator was collecting potential evidence.
And did you know the investigator there?
Yes, I did. Her name is Makoto Hayami.
Together, what did you guys collect?
We collected blue nylon fibers, a shoe print, partial fingerprints, and social media posts.
Let's review the evidence that you two collected. Could you start with the fibers, please?
So the first piece of evidence was blue nylon fibers found on the victim from a blue bomber jacket, and the second piece of evidence was a footprint found in the lot.
Why did you take notice of the shoe print?
Well, there had been heavy rainfall earlier in the week of August 31st and the day of August 31st earlier. So we knew that the prints were relatively new.
Was there any other evidence that you found at the scene that evening?
Yes, we found partial fingerprints on Helmea's glasses.
Did you ever find a match to these prints?
Yes, we did. It was fairly easy to identify due to the rarity of this type.
And what made the prints rare?
The prints were rare because only a small percentage of people have those prints.
And who did the fingerprints belong to?
Well, when we compared them to those already in the database, they matched them to those of Micah Opusay.
Let's move on from the fingerprints. Could you tell me about the social media posts?
Yes, during my investigation and part of my investigation, I found posts from Michael's social media that caught my eye.
I'd like to introduce what has previously been stipulated to and marked as Exhibit B.
Okay.
Let the record reflect that I am showing a clean and unmarked copy of this exhibit. So are these the exhibits, are these the social media tweets that you came across?
Yes, they are.
And why would you say that they caught your eye?
Well, they are disturbing teenage posts amongst the teenage posts about their angst and their 10-year challenge, but this one really did catch my eye.
And with the information from these tweets that you gathered, what did you do next?
I brought Micah in for questioning.
When was that?
I brought them in for questioning on September, and I started the interview around 10 a.m.
And why did you bring them in for questioning?
Well, I wanted to know if Micah had anything to do with Amaya, and so I asked about her whereabouts, his whereabouts, and what they were doing the night of August 31st.
How did the questioning start?
I talked to Micah about their clothes, their whereabouts the night of August 31st, and their relationship with Helmea.
And what conclusions, if any, were you able to reach?
I was able to conclude that Micah's motivation might have come from a love triangle, which many cases I have worked on usually result from.
After your interview with Micah, what did you do next?
After I was done talking to Opusay, I contacted the eyewitness, Corey Abrams, because I wanted to bring her in for a photo lineup and to take a statement.
And when did the photo lineup take place?
Well, when I first contacted Abrams, they were in Chicago for a food truck convention, so we arranged for them to come in as soon as possible when they came back.
And what day was that?
I believe Abrams came in for the lineup on September 10th at 10 a.m.
And did you make sure that Abrams was certain of their identification?
Yes, I asked Abrams multiple times to see if they were certain.
And how confident were you in this statement?
I tried hard to make sure Abrams was certain, but eyewitness testimonies are not the most reliable to base a case on. But however, in this instance, the testimony coincides with all of the other collected evidence.
Thank you. And what steps did you take after the identification?
I put out, an arrest warrant for Opusay.
And when did the arrest happen?
The very same day at 3 p.m., they were arrested and charged for aggravated murder.
And after Micah's arrest, what was your involvement like in the case?
Well, I was mainly on the sideline, but I did talk to Justice Okafor, who was the main prosecutor assigned the case.
And how do you know Okafor?
We have a business relationship from working on previous cases together. I helped her by giving her all the documents and notes I had taken and offered my help.
Were you continuously in touch with Okafor?
Not really, but again, whenever they had a question, I helped her out. And I really didn't get back in touch, with them until about a month later after Micah was already in custody.
Thank you. And why did you have to get back in touch with Okafor?
I received a call from the eyewitness Corey Abrams.
And why were they calling you?
Abrams called me because she was having reservations about her identification of the shooter.
And what did you do from there?
Well, I took note, of course, and then I disclosed this information to Justice Okafor at the courthouse.
And since you disclosed it with Okafor, were you heavily involved in the case?
Not really, but after telling Justice Okafor my involvement in the case, as my duties of being an member of the law were completed.
Thank you. No further questions.
Thank you. State,
Yes, Your Honor. May I proceed?
you may.
You stated in direct that during your time as a police officer, you only completed training for 3 months of investigator training, correct?
Yes, I completed 3 months, but during those 3 months, I completed 300 hours of training.
You also completed 4 months of criminology training, is that right?
Yes, I did, ma'am.
But overall, you only attended 7 months of training for these, correct?
Objection, relevance?
Defense response.
Your Honor, I'm trying to establish the knowledge that Detective Foley has on the case, has on the evidence in the case.
Overruled.
May I proceed?
You may.
So you first heard of this case on August 31st, 2019, right?
Yes, ma'am, that is correct.
And you were one of the detectives that responded to this call, yes?
Yes.
And this was when you first spoke to Corey Abrams, right?
I'm sorry, can you repeat that question? You cut out.
This is when you first spoke to Corey Abrams, right?
Yes, ma'am, correct.
And this was when you received your original eyewitness statement from them, right?
Yes.
And you knew of Micah prior to this case, is that true?
Yes, that is true.
So you were well aware of Micah's minor interactions with the legal system, correct?
Yes, his possession of marijuana and his fake ID.
Is it possible that your preconceived assumptions of Micah, you had preconceived assumptions of him based on his prior minor criminal history?
Objection, speculation?
Can you say more?
Yes, the attorney is speculating that the witnesses' reasons and how they thought about this person before the case.
Defense response.
This is not speculation. I'm asking about Detective Foley's assumptions of Micah.
Overruled.
Thank you, Your Honor. May I proceed?
You may.
Let me ask that again. Is it possible that you had preconceived assumptions of Micah based on his prior criminal history?
No, I do not usually carry preconceived notions. I just reviewed all my evidence every day for this case specifically to see if there were any errors, which none came up.
And this was the first thing you noticed when looking into Micah, correct?
Yes, I did notice his criminal history.
So it's impossible to separate this knowledge of Micah from coloring your knowledge of this case, correct?
I don't think that is correct at all. My duty as an officer is to not carry biases and preconceived notions, as you earlier asked. No, I don't think that colored my opinion of Micah. It was evidence.
You just stated that this was the first thing you noticed, correct, though, right?
Yes.
Okay. Moving on. After the holiday weekend, you received news from the analysis regarding the partial fingerprint, right?
Can you repeat that first part again?
Yes. You received the analysis of the partial fingerprint after the holiday weekend, right?
Yes, that is correct.
And when looking at the fingerprint, how many matching points were found to Micah's?
Several. 7, I think. Sorry.
So that's 7, correct?
Yes, ma'am.
And how many are usually used to determine a match?
I think about, well, there are 150 prints in a fingerprint. We were able to identify 7 of them.
Just to be clear, there's 150 points, as you just said, right?
Yes, there is.
And you guys were only able to identify 7, correct? Just to be clear.
Yes.
And the fingerprint found on Hamea's glasses had an arch print type, correct?
Yes, that is correct.
And you said in your direct that this is the rarest type of fingerprint, right?
Yes, it is a very rare print. It is a rare print.
And this would be about 7% of people in Buckeye, right?
Yes, that would be correct.
So if my math is correct, that would be about 800,000 people out of the 11.6 million in Buckeye. Is that true?
Yes.
So you narrow this down to about 800,000 possible matches to the arch type print, correct?
Yes, but after our analysts figured out that it was an arch print, it really helped narrow down their list of suspects, and comparing fingerprints in the database did lead this arch print to match to Micah Opusay.
Just to clarify, 800,000 people share the same type, correct?
That is correct.
Moving on, you also mentioned the footprint from the scene left from someone stepping in motor oil, correct?
I don't think in my statement never specified motor oil, but there was rain, and if there was footprints there, it would have been placed there. They would have been placed shortly before or during the murder of Hamea.
But you're aware of the footprint, correct?
Yes, I am.
And this shoe print was compared to was conclusive with a size 9 shoe. Is that true?
Yes, that is.
Wouldn't you say that a size 9 shoe is a pretty common shoe size?
Yes, it is a common shoe size.
And what type of shoes match the tread in this footprint?
Converse.
Wouldn't you say that Converse shoes are also the most popular shoes right now in Harmony?
Yes, I do have to say they are popular shoes.
So couldn't these shoes have belonged to a number of others?
Oh, possibly.
And moving on, you also said you also knew of the blue nylon fibers that were found on the body of the victim, correct?
Yes.
And you have no way of determining when these fibers were left on Hamea's body, right?
Not really, no.
So these fibers are also found in many different items of clothing, right?
Yes, they can be found in different items of clothing.
So let me be clear, these fibers could have been from any time because there's no way of determining when they were left, correct?
Yes, that would be correct.
And they also could be from a number of other clothing items, correct?
Possibly.
And Micah admits to going and seeing Hamea the night of the murder. Is that true?
Yes, that is true.
So if these fibers were from Micah, they could have been transferred from a simple hug that night, right?
Yes, a hug.
And moving on, you interviewed Micah, am I right?
Yes, I did interview Micah.
And you stated that you gathered that Micah was friends with Hamea since they were young, correct?
Yes, I did learn of their relationship.
And while interviewing Micah, you informed him of the eyewitness, correct?
Yes, ma'am, I did.
And since you are a detective, you know and stated earlier that eyewitness statements are unreliable at times. Is that true?
Yes, they are unreliable.
Would the general public be aware of the uncertainty of eyewitness statements?
I don't think so. I mean, eyewitness statements usually do coincide with all the other evidence that we collected, which is the blue nylon fibers, the fingerprints, and the Converse size 9 shoe.
So to clarify, they would not be aware, correct?
Unless Micah had some extensive law research, but I do think it is generally common to know.
And isn't it true that the public thinks of eyewitness statements as conclusive evidence, as you just stated?
I would think somewhat.
And did Micah appear panicked to you when you informed him of this eyewitness statement?
A little a little panicked and angry.
And because of this panic, Micah might have admitted to this murder, taking the plea deal after thinking they didn't have a way out, right?
Possibly.
No further questions, Your Honor.
Redirect?
Yes, Your Honor. Considering that it was only a partial fingerprint, would you say that it would be nearly impossible to have 150 points of match?
Yes, nearly impossible.
Thank you. No further questions.
Any recross?
None is needed at this time, Your Honor.
Thank you. Any further witnesses for the state?
No, Your Honor, the prosecution rests.
Are you both ready to closing arguments?
Yes, Your Honor.
No, Your Honor, I would request at least 2 minutes to prepare.
Okay, we'll take a brief 2-minute recess. Okay, state, are you ready to proceed?
I'm sorry, just one more moment, Your Honor.
Okay.
I'm now ready, Your Honor.
Okay. Defense,
Yes, Your Honor. Yes, Your Honor.
are you ready to proceed?
Yes, Your Honor.
Okay, go ahead.
Your Honor.
May it please the court and opposing counsel. Your Honor,
Wait.
imagine
Wait.
you are Micah.
Can we have a moment? We're having technical difficulties.
Sure, hold on 1 second.
Okay, test it.
Can you hear us?
We can hear you.
We're good, thank you.
Thank you. May,
Go ahead and start over.
Thank you, Your Honor. May it please the court and opposing counsel. Your Honor, imagine. You are Micah Opusay. You're a teenager with a minor record caught in the jaws of high school drama. So you do what most teenagers would do. You post some dramatic poetry, you say something passive aggressive. After all kids are guilty of a little melodrama. Once your tempers have calmed, you realize it's best to talk through your problems. The next day, you learn your best friend has been killed. You also learn you're being accused of doing it. You deny the plea deal they offered you. You didn't do the crime, so why would you go to jail? Surely justice has to prevail, right? And then you're told someone is testifying against you as an eyewitness, claiming to see you running from the scene. You are Micah Opusay. You are a kid whose best friend was just slaughtered. You are afraid of getting convicted for a crime you didn't do. Here are your choices. Fight for your freedom and risk rotting in prison for most of your life, or plead guilty and serve 10 years. You plead guilty. You don't know the eyewitnesses stepped down. You don't know what the state never told you. Knowledge is power. The prosecution had it and withheld it from the defense. The day Micah Opusay accepted that plea deal was the day an injustice was committed by the state. Prosecution claims that Opusay is only trying to escape the doors of justice. But the defense has proven that the prosecution withheld information from the defense that could very well change the outcome of the case. By calling Corey Abrams, we have proven that the witness who originally was chosen to testify against Micah recanted her statement, a key factor in getting Opusay convicted given the largely circumstantial evidence. By speaking with Charlie Nguyen, we have determined that the evidence used against Micah was indeed circumstantial. Micah, however, was led to believe that the odds were stacked against him. Yet the prosecution never revealed that the eyewitness had stepped down. This is why my co-counsel and I respectfully request that Micah Opusay's guilty plea be withdrawn in accordance with Rule 32.1. This is a blatant violation of due process. Because of the prosecution's disregard for the 14th Amendment, the wrong killer went to jail, and the victim went without justice. According to Brady versus Maryland, prosecutors are required by the Due Process Clause to turn over all evidence that is favorable to the defense. And according to Kyles versus Whitley, it is a prosecutor's affirmative duty to disclose this information. The state ignored this. The prosecution argues that this violation never occurred, that the outcome of the case would not have been changed had Abrams recanted her statement or not. In reality, the state didn't have a leg to stand on, so they buried the truth. They let a misinformed Opusay take a plea deal. Not only that, but Opusay did not enter the plea deal knowingly and voluntarily. Because the state failed to disclose exculpatory evidence, he entered the deal he could not have possibly entered both knowingly and voluntarily. Today, Corey Abrams told us she no longer believed that Opusay committed the crime, and she would not testify under oath that she did. She contacted the prosecutor's office to correct her mistake. However, what she didn't know was that Micah was never told she recanted her identification, and never would have entered a plea deal had he known. Abrams has now been left with the guilt of identifying a false witness and helping to put an innocent person in jail, all because the state did not disclose information that could have changed Opusay's guilty plea. Not only that, but Charlie Nguyen proved that the evidence provided by the state was largely circumstantial. While the prosecution may argue that the trial's outcome would not have changed even with the withdrawal of a key witness, the linchpin that held this whole case together, Mr. Nguyen has demonstrated that the evidence was simply not enough to convict Micah Opusay. In fact, as an expert witness, he provided an expert opinion that the evidence alone could not convict Micah. Thus, the state's choice to not tell Opusay about the witness recanting her identification could have indeed altered Opusay's response to the plea deal. Today, the prosecution called Detective River Foley to the stand. Detective Foley argued that the evidence was enough to convict Micah Opusay. However, our witness, Charlie Nguyen, directly refused their argument by addressing and explaining each piece of evidence, as well as the reasons why they simply were not enough to convict Opusay. The prosecution called Justice Okafor to the stand in an attempt to prove that the eyewitness's doubts about her identification was not enough to change the outcome of Opusay's guilty plea and did not affect the case. However, Micah was led to believe that he would be found guilty, which is why he took the plea deal. Upon learning an eyewitness was willing to testify against him, he took the deal. Okafor failed to disclose that the eyewitness stepped down. Disclosing evidence favorable to the defendant is a prosecutor's affirmative duty by Kyles versus Whitney, a duty Okafor did not perform. As my co-counsel and I stated earlier, knowledge is power, Your Honor. In this case, the prosecution withheld it from the defense. We proved through clear and convincing evidence that a manifest injustice occurred and exculpatory evidence was not disclosed to the defendant. That is why I respectfully request that this injustice be corrected and Micah Opusay's sentence and conviction be annulled. Thank you, Your Honor.
Thank you. State.
May it please the court. Your Honor, we have come together today to review the case of Micah Opuse. People often say when one door closes, another door opens. Except in this case, Micah shut the door on himself when he killed Haumea on August 31st, 2019. When Corey Abrams redacted their statement, the other door opened. Micah saw this as their chance to escape what they had done and was trying to flee justice. We cannot allow Haumea's murderer to get away. Today, the prosecution witnesses, Justice Okafor and River Foley, have delivered and testifying exactly what was stated in our opening statement. Justice Okafor explained the proceedings of the case and why they declared Abrams' testimony ineffective to the outcome. As they laid out in their reasoning, eyewitness statements are one of the least reliable pieces of evidence to present to a jury. Therefore, no substantial evidence was withheld. River Foley testified that the collection of substantial evidence led back to the defendant and was properly and thoroughly completed. They reviewed for us today the evidence that they found from the original case and showed us that the nylon fibers and the shoe prints and the partial fingerprints and the social media posts and messages links Micah Opuse to the scene with a probable motive. In this case, the burden falls upon the defense to prove that Micah deserves a retrial. However, today they were unsuccessful in meeting the burden of proof. They were unable to prove that the eyewitness statement would have changed the outcome of a trial. Corey Abrams, the eyewitness, said in their testimony that they were good at remembering faces and explained how certain they were and who they had identified in the moment. However, now they're saying that they got it completely wrong. Experts have claimed that eyewitness statements on their own are not reliable, including Justice Okafor and River Foley. They cannot be used as the one piece of evidence used to determine the verdict of a case. Based on the testimony of Charlie Nguyen, you can say that their investigation was completed inadequately. They also admit that most of the evidence they reviewed related to Micah Opuse. The opposing counsel was given a full list of witnesses and could have at any point followed up with Abrams and found out how they would have testified in trial. Their lack of preparation is not a responsibility of the prosecution. We came here today at the request of Micah Opuse to establish a retrial, a man who today has not taken the stand. In our case, the defendant made a voluntary plea. Even if Brady information was withheld, this does not make their initial plea involuntary. Like in Campbell v. Marshall, the petitioner inmate took a plea of guilt before going to trial. After hearing about evidence that they did not know prior to taking the deal, they petitioned for their pleas to be considered invalid. In Campbell v. Marshall, the circuit judge said, "We assume without deciding that under Brady v. Maryland, the state's conduct here in suppressing information favorable to the petitioner would have violated his 14th Amendment due process rights if he had been convicted after a trial without the benefit of that information. So even if information favorable to the defendant was withheld, it would only have violated their 14th Amendment right if they had gone to trial and were convicted without the benefit of knowing that." However, just as in Campbell v. Marshall, the defendant's case did not go to trial before they took a plea of guilt, and therefore, as was decided in Campbell v. Marshall, their plea was not involuntary, even if the court were to decide it was material exculpatory evidence. A voluntary plea, which was taken with counsel, in addition to an overwhelming amount of evidence, cannot be overturned. When one door closes, another opens. Do not let Micah take this chance and leave through the door, escaping justice. With all of this taken into consideration, in favor of the prosecution, we ask that the conviction and Micah's plea of guilt stand. Thank you, Your Honor.
Thank you. Nice job, both teams. At this point, does either team have serious reason to believe?
Your Honor, can defense do a rebuttal?
Oh, I apologize. Yes,
Thank you.
my fault.
Thank you, Your Honor. May I proceed?
You may.
Your Honor, the opposing counsel's claim that any justice would be served here today should Micah Opuse's guilty plea not be withdrawn is unfounded. The defense has not only proven that a manifest injustice occurred when the state did not disclose exculpatory evidence to Opuse, but we have also proven that Opuse did not enter their plea deal knowingly and voluntarily. Opposing counsel claims the eyewitness is unreliable and the eyewitness would not have changed the outcome of the case. Because of the eyewitness testimony, Michael believed they had no chance at trial. However, the state did not disclose the eyewitness step down, which altered Opus's response to the plea deal. The prosecution also claimed in their closing that experts told us the eyewitness was unreliable. Neither witnesses they called were experts. Given the circumstantial evidence, the eyewitness testimony was an important factor in getting Opus convicted. The fact here is that Micah Opus's basic rights were not respected. The prosecution told us not to let Micah Opus escape the doors of justice. But if Opus's constitutional right to due process is ignored, if a child who is accused of killing their best friend and who could not enter a guilty plea knowingly and voluntarily due to exculpatory evidence being hidden from them, and that guilty plea is not withdrawn, if a kid who is under pressure is locked in jail while the killer of their closest friend walks free, what kind of justice is that? Thank you, Your Honor.
Thank you. Good job, both of you guys. That was really great. At this point, does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I will remain on the bench for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any student team members involved in this particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team members in this trial.
Your Honor, the defense doesn't have any at this time.
Thank you. Does the state have any objections?
No, we could not find any.
Okay, thank you. Could I have the judges all submit their score sheets and then turn on their cameras and microphones for feedback?
Yep.
Scott, could you turn on your camera and microphone when you're finished?
Yeah, I apologize. I'm just submitting.
No worries, you're fine. Angelo, do you want to go ahead and start giving feedback?
Oh, sure. Yeah, I'll keep it brief. Yeah, I thought both teams did a very good job. And obviously, I think advocacy is very difficult, I think, over Zoom. I know some judges who have been trying to conduct trials, and then there's always technical issues, which I think, popped up a little bit today, but not that much. But I thought both teams handled them well. And yeah, it's difficult. And I think there's always also a temptation to to rely heavily on your notes and not be responsive. And I thought both teams did a very good job of being responsive, especially on objections. I thought they were all reasonable arguments. As for questions, I thought the witnesses did a very good job with respect to listening to what was said, which I think is always very important. And yeah, overall, I thought both teams did a great job. I think on a broad note, I think the posture of this trial is quite difficult because it's supposedly a hearing, but I mean, there are very difficult legal issues involved, which I mean, it's difficult to, I guess, like work through them in a trial setting in like this sort of context with witnesses, especially I guess on the Brady issue and on the legal status. I worked in the Sixth Circuit and we had a similar issue pop up where essentially the question is whether or not the Brady versus Maryland duty applies to pretrial action, and then there's a circuit split, so like different courts of appeals have said different things. And I thought both teams, it was difficult to directly engage with those arguments, but I thought both teams did a good job of at least knowing that there was an issue there and balancing that alongside obviously the advocacy and looking to elicit testimony from the witnesses. So yeah, great job.
Thank you, Angelo. Scott?
Well, thank you all for being a part of this. This was exciting for me. I enjoyed reviewing the case file and seeing these characters come to life, as well as the way that each team's respective attorneys interacted with these witnesses and sort of brought this this fact pattern into reality. So excellent job. I have not coached, I apologize. I've scored mock a couple of years now. Of course, this is the first time to do it on Zoom, and it's already a nerve-wracking experience. I'm sure, and a difficult task. But I thought everyone handled themselves very well in the unusual pandemic format that we find ourselves faced with. So both teams demonstrated extensive knowledge of the case file, clear understanding of the legal principles. Both teams put on a good show. I did not have access to mock trial in my high school. I certainly wish I had after reviewing your performance and seeing how, clearly challenging and fun and what a good team building kind of thing this is. So well done, everyone. And I won't keep you any longer with my comments because I know you have other trials ahead.
I'll be brief as well. I just want to say congratulations. This was a really well done job by both teams. I think you both did a really good job on cross-examination, having control of the witnesses. You both did a really good job asking like one fact per question type questions, which kind of gives you control. I thought you guys did a good job there. You both had themes and theories, for the defense, it was knowledge is power, and you repeated the word linchpin a few times. So that came through. And this goes for both sides. And the state was the door. Don't let him, escape the doors of justice. I would try to weave those themes and theories a little bit more through my witnesses, if you can do that. But I think you guys did an exceptional job. Witnesses did a great job. All had their individual personalities, which came through. The expert acted like an expert. The police officer, said ma'am at the end of their statements, which is exactly what a police officer would do, would show deference. So I think you all did a really exceptional job. Congratulations. So I think at this point, we all leave and we all go to our next trial. So good luck with the rest of the day, everyone.
Thank you for your time today. Thank you.
Thank you all, and yeah.